Hello and welcome to Enterprise Morning on Enterprise Television. I am Kende Bodu.
Okay.
And I am Henry Igwebike.
All right, we are delighted to start the day with you. And as always, we begin with a quick look at today's newspaper headlines before diving into the main conversation of the day. You don't want to miss a moment with it, right? You can join the conversation by liking, following us on all our social media platforms at Enterprise TV7. And please do well to share. Thank you. So joining us this morning is His Greatness Agadaigo Esquire. He will be sharing expert insights on the issues we have before us. You're welcome, sir.
Good morning to you, Barrister, and welcome.
Good morning.
I can't hear you very clearly.
Can you hear us now, Barrister? Good morning. Can you hear us?
Okay, I'm squinting, Shaba. I wish the audio can be louder.
All right, so our people will get that done in a jiffy.
Yeah.
Thank you so very much for your time. We really do appreciate you. So what newspapers are we starting with?
In fact, we have all the newspapers here, but we'll just start with the Guardian newspaper. So on the big story on the Guardian newspaper, we have sex new, that's SECS, sex new capital rules stir anxiety, stress test portfolio managers.
And also on the top strip, we have federal government to inject 30 billion naira in 74 federal universities as unions urge pact execution.
Okay, we also have Oyo Group decry Nigeria's 150,000 sickle cell births yearly burden.
And also federal government bans mining activities within 10 kilometers radius of bridge nationwide.
Okay, we have Pegasan pushes for minimum wage replacement with sectorial CBAs.
All right, so let's just get to the talking point for today. Barrister, you can hear us now, isn't it? Can you hear us, Barrister?
I can.
Okay, beautiful. Thank you so very much. So let's get to this talking point. Barrister, there's this rumor. We're still hoping that the federal government would talk to it, that the federal government is planning to site a gold refinery in Lagos as against where those golds are gotten from. Does it truly make any sense? Does it speak to physical federalism at this point? Gold is found in Zamfara and Sokoto, and the federal government under President Bola Tinubu, maybe because he is from Lagos, is hoping to site a gold refinery yet again in the overpopulated Lagos. What's your take on this?
My take is exactly your take on it now, that it is inappropriate. It's completely inappropriate. You know, if you watch oil, to the best of my knowledge and your knowledge, oil is not being explored in Lagos, yes.
Yeah.
And Shell and other major oil exploration companies have their headquarters in Lagos. Which is instead of their operational base. And this creates dislocation in the performance of the activities, even logistics, approvals of these oil exploration companies. And because even if the operational command is in the riverine areas and oil producing states, if it is headquartered in Lagos, you know that the line of communication in reaching key decision, consensus, and giving directives will not be so swift as it ought to be. So it makes the performance of the duties and core responsibilities and mandates of these oil exploration companies dysfunctional, as it were. I use that word advisedly. Makes it so in the same vein. That's why I'm not drawing a parallel. Citing headquarters for gold and other solid mineral exploration companies in Lagos, instead of the place where these minerals are resourced, will also make the smooth operation of this mineral stroke mining companies dysfunctional, DYS functional, to make it dysfunctional. That is exactly what is going to play out. And I don't know whether, you know, the present minister of solid minerals was the former commissioner of Lagos State during the time of Bola Tinubu as governor. I don't know whether it is based on this sentiment, ethnic sentiment, state sentiment, where are you from sentiment, and patronage accordingly, that has made him the current minister of solid minerals, who has promised to grow the solid mineral ministry in such a way and manner that it will be a much more reliable foreign revenue earner for Nigeria than even oil. He made that pledge on assumption of office.
Okay.
He made that pledge. But funny enough, it's not sufficient to make pledge. From the way you carry out the administration of your ministry, that's when we know that the goals you have set to yourself are achievable or not, they are attainable or not. One of the steps that must immediately be taken, if that is very lofty goal must be achieved, is that he must be completely unsentimental, untribalistic. He is a servant to all the states in the Nigerian Federation, including Abuja. And so his primary constituency is no more Lagos State,
Okay.
but the entire 36 states and Abuja and FCT.
Okay.
Those are his primary constituents. So in making and reaching key decisions, he must make it in such a way and manner that his priorities are how to foster growth, development, improvement, functionality to the solid mineral sector.
All right.
All right.
And he must put square pegs in square holes. He must utilize, make optimum use of resources available to him, including ensuring that solid minerals in Zamfara and Sokoto, the offices of solid mineral companies, and even the arm of the ministry that oversees the mining of these solid minerals are headquartered in those states where they are mined and explored. So he must put his foot down to do this right thing if he must achieve his own goal that he has set for himself.
Okay.
And if he must also put his name in the legacies of those who transformed the solid mineral sector.
Well said.
Thank you very much.
Well said. So we'll be looking at the Vanguard newspaper, and we have a story there. 52 suspects arrested in Ekpoma for looting, vandalism, and it's coming from the IGP. Now, I want us to look at the detention limits and also how it can be prevented. You know, this kind of situations can be prevented. So how long can, because this is your area of duty, sir, so how long can suspects be detained legally, and how can recurrence be prevented? How can this be prevented not to happen again?
Sorry, please, kindly come again. I'm very sorry, sir. Please, I didn't get you.
Okay.
No,
Okay,
I'm
no
struggling
problem.
to hear you.
Oh, okay. Can you hear me now? I think I should be audible. Okay. So the story here is 52 suspects arrested in Ekpoma for looting, vandalism, and this is coming from the IGP. So now I want us to look at the detention limit and how we can prevent this situation from happening again. So how long can suspects be detained legally, and how can this situation be curbed?
Yes, and just to add on that question, Barrister, remember we talked about this some days back, about students of Ambrose Ali University that were arrested as a result of the protest against kidnapping in Edo State. Yeah. Now the IGP has come to turn that around to call them vandals.
Yeah.
So which is which exactly now? They have been released, they've been recaptured again. Where do we stand in coupled with what Kenny just asked? How long can we keep them in detention?
Okay, can you hear me? Can you hear
Very
me?
well, Barrister.
Okay. Let us start by taking a cursory look at the history of detention of protesters against all forms of injustice, most especially students. And like I said some days ago, in 1993, I don't know how old, which school you were in 1993, but in 1993, student ASU and the students organization came out. They all came out and protested against June 12th heavily for the rehabilitation of June 12th in Benin, most especially in Benin, Edo State. Uniben students, I was not in Uniben then, came and protested heavily. After the protest and they went back to their hostel that day, the following day, military personnel invaded the University of Benin to such an extent that they were just arresting wantonly any student found in the premises. In fact, they broke into the hostels, reported the female students were raped, beaten, injured, maybe they killed some people, and the rest. That was in 1993. By 1996-97, I was privileged to enter that university as a law student. And the injuries, the psychological trauma of that incident in 1993, you could still see it pervasive all over University of Benin, to an extent that in Uniben, I don't know whether it's still there because I've left there quite a lot of years ago, but there's a place that was now named June 12th to remember that horrific event where the university students who protested against the injustice done on June 12th, the university community was invaded, brutalized, put in serious anguish, and completely reduced to nothing as it were. And the next day, students, by the next day after this happened, parents sent for their students and the whole university community was empty. Okay. So you see, but the only thing that is so painful to me hearing this disturbing event is that when those students were protesting in 1993, University of Benin students, one of their co-protesters is Bola Tinubu, who is now, fortunately and most surprising, now the President of the Federal Republic of Nigeria. And I'm sure he had his own fair share of pains and anguish he suffered for protesting for the actualization of June 12th election of 1993. So as president, even if we have complained of so many failings of his government, but one thing we will say is that such a dark episode in our history ought not to be repeated under any guise ever again.
Yeah.
I expected that even during, although I did not watch his inauguration speech, but I want to expect that he must have even recalled that event and made a clear declaration that never again will this happen in our land. Never again. Never again. But unfortunately, we are seeing it happening time and time again under his watch, under his very watch. We are seeing it play out even globally, giving Nigeria global bad name characterization. So it's completely unfortunate.
Okay.
And I think it's a very poor, painful, and distressing legacy by the Bola Tinubu administration. Having said that, how long can suspects who have been detained be lawfully arrested before they are charged with court? Section 33 of the 1999 Constitution says 48 days, 48 hours, that's 2 days within 48 hours, as long as there's a cause around the area where they have been arrested. And we know that there are courts around that every manifest where the magistrate court or high court. So not more than 48 hours. Anything over and above 48 hours amounts to an unlawful arrest, detention, and a gross violent violation of the rights of the suspect. Because at this stage, they are still suspects and they are presumed innocent until proven guilty. So they have a right of presumption of innocence. And again, so I hope that when the police, you arrested them, granted them bail. So it is, I consider it very uncivilized and even barbaric that having granted people bail, you now went to arrest and detain them. If you have now concluded your investigation and you now have your proof of evidence with which you want to charge them to court, the civilized thing is to invite them through the addresses that they have provided, or to invite them through their shorties to file court summons and serve on them. Then if they fail to honor court summons, because at this stage now they are not arresting them again to do further investigation. If they are arresting them again and detaining them, is to charge them to court for a known law, not an unknown law, not an expired law, not a law that has been abrogated. And I hope they will not be charged for wandering, and I hope also they will not be charged for conduct likely to breach peace.
Okay.
I hope not. I hope they'll be charged for clear-cut and well-defined offenses that have been provided by extant rules, regulations, and laws of the land that can be authenticated and verified, having had sufficient time to carry out diligent investigation. So I hope that, because these are the abuse in our criminal administration procedures in Nigeria. And let me just make this, I think the time has now come where the prosecutorial powers of the police must be withdrawn. The police, I hope you heard. Can you hear me?
Yes.
Yes, very well. Yes, we can hear you.
Yes. It is now time for all Nigerians, including we civil rights advocates, in collaboration with the media and civil society organizations, to now start a serious agitation and campaign that the prosecutorial powers of the police have been abused again and again over time and has made nonsense of our criminal administration goals and objectives. So it needs a full, total, and complete withdrawal. Police should be restricted to only investigation, and in conclusion of their investigation, they should hand over their exhibits, their evidence, their findings, their facts, and the entire case file to officials of Ministry of Justice to now carry out a verification process, an independent verification process, where they will now have to even do personal scrutiny of the witnesses the police have assembled. Number one, to see whether there is simply a prima facie case to start with, one. And secondly, whether with the evidence and witnesses provided by the police, it is enough, it is sufficient to sustain a criminal charge in court, so as not to waste scarce commodities, scarce resources scarce state resources and resources allocated to Ministry of Justice to pursue shadows, which will end up as failures for lack of diligent prosecution.
Yes,
so
we truly do
until
hope.
we remove this prosecutorial powers from the police, we will keep having these embarrassing scenarios over time and time again, so that the police can fully focus on investigation of cases and leave the expertise of officials of Ministry of Justice to deal with the prosecution of alleged offenders.
All right, that's very well said, Barrister. We truly do appreciate that, and we hope that the police authority would listen to some of these things and do what they should do, because they say police is your friend.
Yes.
But I do not know if Nigerians believe that police is their friend, because when you see a policeman, it's no longer looking like your friend. Even when they are your neighbor, your close-door neighbor, you have to be very careful. But of course, Barrister will still be here to take us on our main conversation. When we return, legal battle over Tinubu's reverse emergency nears a verdict. In the Beat Enterprise morning it is.
We'll be right back.
It's glad to have you join us. This is Enterprise Morning, reaching you from Enterprise Television. To our main conversation for today, where we have that the Federal High Court in Abuja has fixed Friday, March 9, 2026 to deliver judgment in the suit challenging President Bola Tinubu's declaration of a state of emergency in Rivers State. The case was filed by the Civil Society Observatory for Constitutional and Legal Compliance, which is contesting the legality of actions taken by the President during the emergency declared last year.
Very true. Justice James Omotosho set the judgment date after counsel to the plaintiff, Nnamdi Nwokocha Haiwi, and lawyers representing the defendants adopted their written addresses and presented arguments for and against this suit. The defendants include President Tinubu, the Attorney General of the Federation, and other relevant officials. In the suit, CSOCLC questioned the President's authority to remove elected state officials and appoint an interim administrator during a state of emergency.
So let's get talking. We still have His Greatness Agada Ego Esquire. Thank you so very much, Barrister, for being here. Truly do appreciate your time. Now let's get talking on this. It's been close to 3 months after the suspension of the state of emergency. Yeah. Fubara has moved on. I don't think he even remembered he was declared, his state was declared the state of emergency. Yeah. He has a much more bigger battle to fight with his godfather, yes, on week here. So I don't think that would be of any business to him. But to us in the media, it is. Barrister, what's your take on this latest information that we have? Does it truly make any sense, or is it basically a textbook experiment in the law?
Sorry, I want to be very clear on what is that exactly?
Yes, so civil society organization has gone to make claims that President Bola Tinubu is not supposed to have declared a state of emergency in Rivers State. So that's what we're talking about. We're asking, is this another frivolity? Is this a textbook court's judgment for students of law to learn? Does it make any sense to Nigerians again, as of today?
Okay, first of all, my first concern is that, well, I have never appeared before Honorable Justice Omotosho at any point in time, but I know the PDP have raised issues, the leadership of PDP, that many of their cases that come before him, he do not get favorable judgment, but rather it's their known opponents that always get justice. So I was thinking that this kind of case it will be given to another judge outside the 3 judges that PDP named that he alleged to be working with the FCT minister Yesom Wike. This kind, because I'm sure you know in cases that said that a judge handling a matter should be above board like Caesar's wife. Nothing remotely should be even mentioned about him. And I don't know in Nigeria now. I don't know whether we are doing the way things are happening, especially in the judiciary, whether we take one step forward 100 miles backwards. That appears to be what is happening, because the proper, and it appears to, we are not even learning from civilized judicial system. We have refused at this point in our nation's history. Our nation's judiciary have not bluntly refused to learn from improved judicial services of foreign nations. In foreign land, when you raise any issue about a judge, even if you say, oh, I don't like the face of the judge, the supervising authority, in fact, first of all, the judge in honor, the judge, you can see me return to judge honorable, based on the distinction of the judge, because of the judge's honor, because of the judge being like Caesar's wife, the judge will in honor recuse himself, showing that it has nothing at stake, it's not interested in the matter, it has nothing to gain from the conduct of the proceeding, and it has nothing to gain from the outcome of the proceeding. That's what the judge will do. He will recuse himself as with the speed of light. And even the head of the court will transfer the matter immediately, because so that the judgment is not tainted. This is the way we know justice when we are children. But times have changed. Times have changed so much in Nigeria. The judicial era of 1980 and the judicial era of this present time now is like, the difference is like as wide as from Nigeria to America, or even or wider or longer. The difference is too wide that people will complain about that they do not want a judicial officer to preside over a case. Then the chief judge of the federal court says, judge must hear the case, whether they like it or not. Even the judicial officer himself, he must hear the case. He must hear it. That one alone has depleted the confidence of the litigating public in our judiciary to the.
Are you still with us, Barrister? Yes, I think we lost the barrister there. We hope he would reconnect and get talking to us, because it's very important. He is a lawyer. He understands all of this better. We can only do the listening part. But let's even have our go on what the barrister was talking about. And it's courageous enough for barrister. Not all lawyers would love to, go against an industry, an ecosystem they play in. But barrister has always been there, courageous enough to speak to some of these things, even when he is a part of the system and he has a skin in the game. But that shows courage and someone who truly wants a change in the judicial system in Nigeria. For some of us that are not lawyers, who do not have a skin in the game, we do not even know who to run to. Nigerians would rather love to go to a very dark man to seek justice than run to the court. So this is to show you how debased our judicial system and process is in Nigeria.
Yeah, and he said something. He said the system has really changed, because he said even if you can look at the system itself, that it is not really a student that wants to study law might not really be comfortable, because the system is not understandable, right? Because things are really turned around.
Upside down.
Is back.
It's back. Yes, barrister.
So please, as I was saying, thank God your volume has come up. Thank God for that. has brought
Yeah.
in full. So if justice runs on perception, impression, it is possible that you can make a very good, sound judgment. But once once the litigants, the users of court, already perceive you to be compromised, no matter how well researched your judgment is, no matter how scholarly your judgment is, no matter how futuristic your judgment is, no matter how well grounded in law, in facts, in philosophy and logic your judgment is, then your judgment will serve no purpose, because it's supposed to restore confidence in the society. It's supposed to restore order. It's supposed to restore belief of what the law and what the position of the law should be. So it's for you to achieve that, you need confidence of those who have appeared before you. You must buy their confidence. You must have their confidence. So at any stage of proceedings that a litigant says that I do not have confidence in this judicial officer, the moral thing to do, the logical thing to do, the ethical thing to do, the philosophical thing to do, and the legal and constitutional thing to do is for the judge, in honor of the court he sits or she sits, because that court is the judge is presiding over. The court must first give that court honor before the court can receive honor from the audience and the litigant. So in honor of the court the judge is sitting, the judge must of necessity recuse itself from that matter. Not because the judge feels like, not because the judge wants to. The judge may want to stay in the matter, but the honor of the office of the judge, the honor of the court, prevails on the judge, on the presiding officer, to immediately recuse itself, even where the presiding officer, maybe like, for example, now the chief judge of the Federal High Court, or the president of Court of Appeal, or even the CJN, is putting to the judge that no, you must hear this case. The judge will say, no, my lord, even though I would have wanted to hear this case, but because one of the parties before me have expressed their lack of confidence in me, I cannot, in honor of the court I preside, go further, go ahead and hear and determine this case. This is what is now really missing. This is the missing key. This is the vacuum now in the administration of justice in Nigeria. Because we now see cases, litigants will say, I don't want a judicial officer to hear a matter. And the judicial officer will say, I must hear this matter, whether you like it or not. If heavens will fall, let it fall, but I must hear the matter. That cannot be. That is not ethical. That is not legal. That is not constitutional. That has, to a large extent, decimated the confidence the Nigerian litigating public have in the Nigerian judiciary. So based on that, let me not speak for myself, and let me talk much about the judgment because it's sub judice.
Yes.
But based on the fact that people do not want certain judicial officers to preside over matters, but the judicial officers have been put to preside over the matter, whether any person likes it or not, even before they give their judgment. The many confidence of the Nigeria audience, because it's a public, don't forget that it is a public suit, a suit of public interest.
Yeah.
A suit of high public interest. But because it's a certain judicial officers that the public, the generality of the public, do not want to preside over the case, even before judgment is given, they have lost interest in the case, and they already believe it's even given that the cause of justice most likely may not be served, and that's get our rights. Judges that people have made their minds known that they don't want them to preside over matters should, in honor of their judicial offices, immediately recuse themselves.
So what you had the question there?
So the thing is, okay, now what message does this suit send about civil society's role in governance? What's that tangible message it sends? Can you get me?
Okay, you said something.
Yes, I'm saying, what message does this suit send about civil society role in governance?
The message is that we are all members of civil society. You, me as a radical advocate,
yeah.
You as a radical media outfit, and people who are interested to see a better Nigeria, a better judicial system. We must all be vocal. You know, many a times the light shineth in darkness, and the darkness does not comprehend. People who want the status quo to continue in our judicial system, they want all of us to keep quiet. They don't want us to talk. If you watch, just when Bola Tinubu came in 2023, the Attorney General then and some other legal practitioners always tell lawyers, don't talk to media, don't talk. Why don't they want lawyers to talk? Freedom of expression is guaranteed in all circumstances. In fact, it's absolute to a manner. Why? Because lawyers will say the truth, we expose what is wrong. When they say what is wrong, it is supposed to agitate members of the whole of the society to now go for mass agitation that the right thing should be done. A society where there's the majority are blind, one eye man will be their king. But like I was saying, when light comes, darkness disappears. So we should be the light of Nigeria. We should say the right things. We should say the truth. The Bible says you will say the truth, and the truth will set you what?
Free.
The truth, what? So why is everybody afraid? Why? Including even senior lawyers. So many senior lawyers.
Because everyone is standing on the mandate as we speak, barrister. The judiciary, unfortunately, they are standing on the mandate. The legislators standing on the mandate. The executive are the mandate themselves. The press standing on the mandate equally. So when everyone is standing on the mandate, truth becomes very difficult at this point. That's just the big reasons.
The truth about the whole thing is that we have a higher mandate to stand on. We have a higher mandate. And of course, the mandate is not Tinubu's mandate or APC's mandate. The mandate is that when you shall know the truth, and the truth you free. That is our collective mandate, bounded to our presence. When we fail to stand on that mandate, any other mandate we stand on, we will crumble with it, and we may collapse into a pit. So this is our true mandate. We each and every one of us, we must not be so bothered about the consequences. What will happen to me? I will be disciplined. I will be punished. I may be attacked in one way or the other. That's what my clients will be attacked. I will lose cases in court. I will be victimized. I will be ostracized from society. Maybe if as a lawyer now, I can express fears that I may be debarred from the Nigeria Bar Association. Those are primordial sentiments. Those are primordial sentiments. We serve divine purposes. If as a lawyer, I'm called to serve divine purposes. You know, one of the meaning of lawyer means to speak out. So I'm surprised when people say, keep quiet, don't talk. Meanwhile, his name is speak out. That is being functional, dysfunctional. When as a lawyer, when as a media outlet, we fail to speak out. One, we fail to say the truth. We fail to say it consistently. until even the deaf will hear, then we are being dysfunctional, and we will also be held responsible for our perverse and dysfunctional Nigerian society. So the only way out for us is we must stand out, we must stand tall, we must stand strong, say the truth, stand by the truth, live by the truth, suffer for the truth, and most likely die for the truth.
Wow.
Thank you. Thank you so very much, Barrister. We really love that ending. It was yes.
I hope you also, like me, one day you'll be ready to die for the truth.
Yes,
I hope so.
We hope so. That is the dream.
Pardon, if I can see that you're enjoying your husband, happy birthday.
That is actually very true. You know, that is the clarion call for everyone, because we can't continue this way. I remember in 1998 when Daniel Kanu, there's one guy called Daniel Kanu who started, the youth earnestly asked for Abacha. You know, he gathered all persons together, organized the 1 million man march in Abuja and all that. They all did all they were supposed to do because they were standing on the mandate of Sani Abacha. But unfortunately, God took course and everything all faltered. So, just like Barrister did say, for those who are standing on the mandate of President Bola Tinubu, that have made it very so sad for the judiciary to not become the judiciary we used to know. During the military, judiciary were one of those sector, system, ecosystem that was there to champion the cause for the freedom of speech and the right for persons. But now, with democracy, the judiciary has fallen and become an arm or subset of the executive. Very so despicable, but that is the reality with Nigeria today. Thank you so very much, Barrister. We truly do appreciate your time, as always.
It's something to flex. Anytime you call me, call me 12 a.m., I will answer you.
Thank you for being present.
We truly, honestly appreciate your time, Barrister. You've been a very good...
Call me 12 a.m. and see whether I will answer you.
No, we'll call you, don't worry.
We'll do just that. We truly do appreciate you and never take your kindness for granted right here on Enterprise Television. Your insight has been a welcoming one, and we truly do appreciate that you provide the information to our thousands of audience watching from wherever they are doing that around the world. Thank you so very much, Barrister. But that's just about the time we have for today. We'd love to say thank you for making this a date. Please do well to follow us. You can find us at Enterprise TV7. I am Henry Igwibike.
And I'm Kehinde Bodunrin.
Have yourself a splendid day. God bless you.
God bless Nigeria.
Bye-bye.
Bye for now.
Why you not for her? I don't touch her on the side. Don't call her to me. This month.